Right, so for everyone starting the second session, if anyone's wondering who I am, I'm Patrick Saul. I'm the other CPD guy who's now involved with helping set up the seminars, and the second half is my responsibility. So these are the topics that I picked that I thought we could have some use for. And the next talker, or the next speaker, sorry, is Samira Tagharvey, who's a criminal lawyer who acts and works in New Zealand, and she has a master's degree in public law. She's a very intelligent lady. She's made a name for herself in New Zealand, having earned the nickname Bulldog from a former government minister, and whilst we have other nicknames for her that are a little more bovine, she is someone that helps us a lot in deportation liability and understanding and preventing that for our clients who fall into trouble either during their work visas or post-residency. So Samira's coming to talk about how to better protect your clients who do get into trouble in criminal proceedings, and how we can help work with solicitors and other criminal lawyers to improve our clients' standing and keep them here lawfully. So Samira, if you don't mind, please welcome Samira Tagharvey.
Hello everyone. He doesn't talk to me like that, he just talks about me like that, which was quite lucky. I was quite worried when he was giving that introductory speech. I actually didn't know Mr. Moses and Mr. Laurent are going to be here. They are way more experienced than me, so I hope that they will approve of what I'm doing today. Okay, I've been asked to talk about the interface between criminal conviction and deportation liability, and specifically the provisions of Section 106 under the Sentencing Act. It's unfortunately becoming quite problematic because as defense lawyers, as criminal lawyers, we have been getting a lot of inquiries from people who were not aware that they would be liable for deportation when they are on a residence visa, let alone the temporary visa. And also they get served with a deportation notice after they get a criminal conviction, and pretty much it's too late to do anything about it apart from going through the appeal process. So I'm just going to talk a little bit about the deportation liability in respect of conviction, and I'm going to focus first on the residence visa holder. I'm not talking about immigration advisors, I'm talking about people, normal people. They're not aware that they would still not be safe from deportation when they're on a resident visa. They think while the resident visa is issued, then they are safe from deportation and they can do whatever they like to do. But Section 161, which I believe it's happened after 2009, immigration is not really my area, so if I was mistaken about anything, you can just correct me. But in terms of the Section 161, Section 161 makes it very clear that a resident visa holder is liable for deportation if she or he is convicted in New Zealand or elsewhere. So it's not just New Zealand, they're not limiting it to New Zealand, for an offense for which the court has the power to impose imprisonment for a term of 3 months or more. And that limitation is for 2 years. So from the date that the residence visa is issued, there is a 2-year period. So if within that 2 years, they commit a criminal offense, which carries up to 3 months imprisonment or more, then they will become liable for deportation. One thing that is quite important to know for you is that just carrying up to 3 months imprisonment is enough for the deportation liability to kick in. They don't have to go to prison. They don't actually have to serve any prison time at all. For example, with drink driving or traffic offenses such as careless driving causing injury, dangerous driving, simple sustained loss of traction, all these very minimal criminal offendings, they all carry up to 3 months imprisonment. But 99% of the time, the people will just get $400 fine and a disqualification. That is enough. That conviction is enough it doesn't matter what actually the sentence was, the conviction is enough for deportation liability to kick in. And my understanding is that the deportation notice or the liability will hang around the neck for another 10 years. So one thing which is, as I said, was very important is that if they hold a resident visa, within 2 years of holding a residence visa, they get convicted. And as I said, could be any traffic offenses, which carries up to 3 months imprisonment or more, then they will be liable for deportation. And my understanding is, again, based on experience, dealing with a lot of clients in the past 2-3 years, they get served with a deportation notice. Because we had a client who was a doctor, and he didn't listen to us to apply for a discharge without conviction. He was charged with drunk driving and careless driving causing injury. And even the judge asked, would you like to put in an application for discharge without conviction? He was one of the very famous doctors around the South Island, and he said no. He was within the first 2 years, and as soon as he got the conviction within 3, I think, days, he got served with a deportation notice. And I believe then, of course, we referred him to Kim, and I don't know what's happened afterwards, but I think they went through a very lengthy process just to get him to stay in the country for another 3 or 4 years. So that was one of the examples. So it's really, really important to keep that in mind. So, longer story short, Section 161 means that having a residency does not make your client safe from deportation. So they are still carrying that risk if they commit an offense within that 2 years. I went through a little bit more about Section 167 and what the immigration minister can do, but I think I will leave that part with you guys to read because it's purely immigration related. So, one thing which is quite important to know is that appealing the deportation notice under Section 162 of Immigration Act 2009, you can appeal to the tribunal on humanitarian grounds. It's very unlikely, actually, for a lot of people to end up having any humanitarian grounds. And the tribunal annual report in 2014 and 15 noted that 56% of such appeals actually failed. And this is the report that us criminal lawyers continuously use in court. And it is judges and magistrates, they put a lot of actually weight on that report because it's been researched and that is the outcome. So in terms of what can be done to avoid the deportation notice, or what can be done about the deportation liability when they actually get charged with the criminal offending, it is really important for them to bring it to your attention. A lot of times they don't do that because they don't regard drink driving or dangerous driving as serious offending. They just think because they got a fine and a disqualification, that's fine. It's not important. It's not a big deal. So they don't even, as far as I know, they don't even bring it to your attention. So you wouldn't know, actually, they have a conviction or they're going through court. But once they get charged with any of these qualifying offenses, it is important for them to know of the possibility of deportation. One thing that I want to mention is that a lot of people talk about the potential possibility of deportation. But from our point of view, and we have spoken with Professor James Evans from Auckland University, he does do a lot of legislation interpretation and stuff, and his reading of Section 161 is that it says a residence visa holder is liable for deportation. He says there's nothing about the potential liability. It's mandatory liability. From his point of view, the immigration doesn't have a choice. They will have to issue a deportation notice. So it's not about potentiality, it's about pretty much certainty of having that deportation notice served on the person. So, of course, one way of avoiding a conviction is defending the charge, but again, based on experience, a lot of these traffic offenses, at least, they can't be defended these days. It's very difficult, technical defenses are gone. So the only option you're left with is to advise them of a discharge without conviction under the Section 106 of the Sentencing Act. I'm going to go through briefly to explain what discharge without conviction is. It's kind of obvious from its title. It's about putting in an application to court and asking the judge not to convict your client. So they will still get the sentence, they will still get the penalty, they're just not going to get the conviction, which means the criminal record will stay clean. So they don't have any they don't have any obligation to disclose that conviction to anybody or that charge to anybody. So Section 106, I put in the footnote number 1, I put the section under Sentencing Act 2009. So the judge has the discretion upon the defendant. It's on page 5 in the footnote. If a person who's charged with an offense is found guilty or pleads guilty, the court may discharge the offender without conviction. So it's a may. It's completely at the judge's discretion. So you can do so much. You can put all the submissions, all the affidavits, everything to the court, but it comes down to their kind of discretion of what they're going to do. The test for a discharge without conviction was very well explained in a case called Queen and Hughes. There is a 3-step test for a discharge without conviction. The court requires to consider first the gravity of the offense, which is something that criminal lawyers need to really get into that, not immigration lawyers. The second, which is really related to you guys, is the direct and indirect consequences of the conviction. And that goes to the deportation liability goes into the heart of direct and indirect consequence of the conviction. So that is something that we're going to use when there's immigration, when there's a deportation liability, that goes to the heart of direct and indirect consequences of conviction. And then the last step is weighing up of the consequences with the gravity of the offense. One thing again that you need to know, and I mentioned that in page 6, is that the test under Section 106 is not about certainty. Okay, so it's not about whether definitely the person will be deported or not. The test is whether there is a reasonable and appreciable risk. So if there is a moderate, even moderate risk of deportation, then that should be enough to satisfy the test. Because unfortunately, a lot of judges are mistaken, thinking that Section 106 is about the certainty of the consequence. And that's definitely not the case. So the case is just real and appreciable risk. And for example, in Queen and Jackson, the judge said, I do not consider it is possible for someone in your position to demonstrate in advance how a professional body, immigration officials, or others will react in the face of a conviction, because nobody knows that. We don't know what the immigration officer is going to do. So, but as long as there is a risk, there is a consequence. And under Section 106, this consequence, in order for the judge to grant a discharge without conviction, the judge needs to be satisfied that the consequence of the conviction is out of proportion compared to the gravity of the offending. So someone being deported for a drink drive conviction is obviously, when you're weighing it, the consequence is huge compared to the actual crime. That's why judges do consider it and decide to grant discharge without convictions. So I summarized the point here on page 7. We had a doctor who was a surgeon residing in Christchurch. He was a Canadian citizen. He was here with his wife, and he was within the first 2 years of his residence, and he committed a drink drive offense. So his case actually took 2 years to get to the point that he was sentenced, and eventually he was discharged without conviction. And Community Magistrate Holmes, I put a quote there from the decision, and I think I have printed it, I have given the decision as well, a copy of that. The magistrate said, moving to the situation with immigration, as I said, you are a Canadian citizen. You intend to apply for permanent residence in New Zealand, and you're concerned that a conviction might affect that application. I have read the long, detailed affidavit from your immigration advisor, Mr. Saul, and he details the consequences of a conviction on your residency status. It seems that all sorts of dire things can happen to someone who has a temporary visa and then receives a conviction, but essentially you would be under the shadow of deportation liability for 10 years if convicted. And then she goes on to say that I do accept that this consequence would be out of proportion to your offending. And she did discharge him without conviction, and he did get his permanent residency within 3 weeks because immigration did not want to deal with it until the outcome of this court was determined. So, as I said, if there is a potential deportation liability, that should meet the real and appreciable risk. I decided to go through some cases because we do get a lot of inquiries from immigration advisors thinking that when people are charged with more serious offenses, then there's no point at all to actually apply for a discharge without conviction. Some of the cases that I have put in here, and I have given a copy of that to Christina. I will mention them briefly. One thing also that you need to realize is that we come across police opposition all the time. There's not a single discharge without conviction that they would not oppose. So, and one of the main points that they raise in their opposition is that it's not the court's duty, it's not the court's job to grant a discharge without conviction and hide the conviction from immigration authorities. So that is something that we constantly come across, where we do have authorities to say that if that's not the job for the court, then God knows who can do that job, because why do we have a Section 106 in the first place? If travel rights cannot be determined by the court and should be left to the Minister of Immigration, judges, even High Court judges, have said that is actually the role for the court to make that determination. I've put some of these cases here which actually mention that point. In Gian and the Police, which is a very, very good case, it was about dangerous driving and failing to stop and colliding with a truck. The defendant caused, it says moderate, but you know, I was aware about, I knew about the case. The injuries were not moderate. It was to the victim and his wife, broken ribs and bruises, fractures here and then. And so the injury were quite serious. And the judge decided that, notwithstanding the observations by the Court of Appeal and in other cases in this court, there will be cases where Section 106 discretion should be exercised and the matter therefore not left for the determination by Minister of Immigration. And then the court goes to say, it is a question in this particular case as to whether this momentary inadvertence resulting in a driving offense of moderate seriousness and assist against an otherwise exemplary life should have the automatic consequence of the risk of deportation hanging over this man and his family. So judges are fully aware of the deportation liability these days, especially High Court judges, but I can tell you, District Court judges and magistrate, they're not. So that needs to be brought to their attention. We had a case which we had a judge at Manukau, and I think it took us 7 different sessions to actually teach the law to the judge, because he simply could not understand. I think Kim did at least 7 affidavits in that case, and he still couldn't understand. And pretty much the last session, he said, I'm just granting it because I'm sick of it. So, but it is highly important to simplify the law for them, because even for judges, it doesn't make sense that for a drink drive, someone would be deported. So they don't understand. They say, well, what's the likelihood of that happening? And when you say it doesn't matter, it could happen, and that's enough. And it has happened. So it is important to bring it to the judge's attention. In the case of, there was another case, Smoothie and Police. This was about travel rights to Canada, but the same principles apply, okay? Again, the judge said, if the judge cannot make a decision about discharge without conviction, if this approach that is not a matter for the court is right, then it is difficult to see how any Section 106 application on the basis of the consequences of a conviction on travel rights could ever succeed. And this was a very good decision, which we usually quote in our cases. There was a very recent case where Mr. Laurent was involved, actually, Rahim and Queen, and this is really important because it's a 2018 decision and it's a Court of Appeal decision. As far as we are aware, this is the highest authority on deportation liability and discharge without conviction. So this case will be quoted probably all the time from now on. This was for Mr. Rahim was facing an indecent assault charge, which carries up to 7 years imprisonment. He assaulted a girl indecently in, well, that was the alleged assault where in the lift, apparently. I actually attached the decision there. And Mr. Laurent did a very detailed affidavit explaining the consequences of the conviction and the liability for deportation upon conviction for Mr. Rahim. The district court judge took a negative view, although acknowledging Mr. Laurent's affidavit and accepting his affidavit, saying, yes, the consequences are out of proportion, but the gravity of the offending is huge. So comparing those two things, I can't grant a discharge without conviction, no matter the consequences to the defendant and to his wife and his child. So went to the High Court, approved in High Court, and went to the Court of Appeal. And the judgment, the decision was overturned. They granted the discharge without conviction. And they actually said that all three justices at the Court of Appeal said in paragraph 30, in the present case, however, Mr. Laurent's expert opinion establishes that the real and appreciable risk is significantly higher than the mere prospect of deportation. It is that, after Mr. Rahim has undergone all the statutory processes, a conviction is likely to result in him being required to leave New Zealand. That would be devastating for him and his family. We are satisfied on this basis that Judge Tamano erred in classifying the consequential risk somewhere between the middle to the higher end of the scale seriousness, but not at the extreme end. So they obviously took the affidavit from Mr. Laurent into account and accepted that even for a serious charge such as this, a deportation liability is too much of a consequence, and he should be granted a discharge without conviction, which he did. So this is a fantastic case. I do suggest you to actually read the case in detail. It's a very good decision. De Souza was actually another interesting case, again 2018, and that shows that deportation liability is becoming of an issue. It's quite important, and judges actually are becoming more and more familiar with the concept. So in De Souza, Mr. De Souza assaulted his wife using an electrical cord. If you read the decision, it was a very, very nasty assault on his wife. And again, it's a high court decision. The district court judge did give him a discharge without conviction, but the police appealed it to the High Court on the basis that he shouldn't have gotten a discharge without conviction. And in paragraph 23, the judge said they include the need to obtain a character waiver. Actually, Mr. De Souza was only on a temporary visa, which is quite interesting, not on a resident visa. They include the need to obtain a character waiver, and if he cannot, he will be unable to obtain a working visa and will be parted from his family. Applying the real and appreciable risk test, I am not persuaded that the judge was wrong in finding the consequences were made out of as required. He assessed them as dire in the context of possible deportation and separation from his family. So again, it shows the pattern between district court judges and high court judges. But saying that, it's never a guaranteed option, because some judges unfortunately still apply the test not in a correct way and come up with a decision which is wrong, but you do have the options of appealing it. I've attached a few other decisions and a newspaper article because I've seen a few lawyers actually making that application in court and judges just making a decision there and then, like giving an oral decision. So all these decisions are not written. And I've seen a lot of students on a student visa to get a discharge without conviction because of the potential of deportation liability. So that would be in terms of the resident visa. It's a little bit different when it comes to temporary visas, and I think Katie was quite interested in that. She's quite annoyed with that section. Section 1571 of the Immigration Act talks about the temporary entry class visa, and unfortunately this section talks about deportation liability will kick in for any criminal offending. So it doesn't talk about a conviction. No matter whether the person gets convicted or not, apparently the immigration does have the power to issue a deportation notice. However, again, my suggestion is that based on experience, I've seen a lot of people on a temporary visa getting a discharge without conviction. So obviously the court will read down this section, because this section is in direct contradiction with the New Zealand Bill of Rights. Everyone in this country under Section 25 of New Zealand Bill of Rights is entitled to be presumed innocent until proven guilty. So deporting somebody on a basis of a criminal offending is in contradiction to that. And if it comes down to that, and the person gets a discharge without conviction and then gets served with a deportation notice, our suggestion would be to appeal it straight away, because you do have good grounds for an appeal. And if the appeal didn't work, we would suggest the last step would be judicially reviewing the decision through the High Court, because 99% I can tell you it's going to work, because this section does not accord with the New Zealand Bill of Rights, and being granted a discharge without conviction would simply increase their chances of having a successful appeal or a successful judicial review. So don't think because it just talks about criminal offending, you just tell them to go and plead guilty and get convicted. I don't think that's actually necessary. So in terms of consequences of conviction on citizenship, that doesn't come up very often, because the consequence is like 3 years postponement of them getting a passport. But again, we've done a few discharge without convictions for people who did not want to wait for another 3 years. They were mainly refugees in New Zealand from Middle East countries, and they were in a real need of having a New Zealand passport in order to do their business out of the country. Because, for example, I'm from Iran. It's like, God forbid, as soon as you go to the airport and the customs and you produce your Iranian passport, are like all sorts of questions, and is this you? Yes, it's me, because you're covered completely. And so having that passport is like having real freedom for a lot of people, especially people from Middle East. And again, if your name is Ali, then you have to go through all sorts of security checks, apparently. So we had a guy who was on a simple careless driving charge. Simple careless driving. It just carries a fine. It's just the finable offense. But that is enough for that 3 years postponement to kick in. So everybody told us, don't bother, it doesn't matter, they're not going to grant it. So we said, let's give it a go and see how it goes. So the case ended up before Judge Ed Manukau, and we explained why he needed to get his passport. He was the only one in the family, a 19-year-old, who would have had to wait for 3 years to get his passport. He wanted to travel to Australia for work and a study. He had real difficulties every time getting through the customs. So all these things were explained to the court, and the judge made a decision that, yes, that even that 3 years, kind of waiting for 3 years, would be a consequence which would be out of proportion for him. So, and I have heard that since that case, which was 9 months ago, another 5 lawyers have applied for discharge without conviction on this basis, just that 3 years postponement, and they were all from Middle East. So that's something to keep in mind, because that could be a big deal for some people, and a lot of people don't know about it. So they just go to court, plead guilty, and they don't know that they have to wait for 3 years. So that comes as some sort of a surprise to them. So, because if they, they will have to be exceptional circumstances if they want to apply or kind of for their residency a little bit sooner than that 3 years postponement. And I did a bit of research, and exceptional circumstances, for example, is not finally defined, but one example that we found was that the crime you were convicted is not a crime in New Zealand, like homosexuality. But how often does that happen? Not very often anymore. So that would be another thing to bear in mind. I wanted to talk to you about the time frame, because I have received a few calls from a few immigration advisors. They were quite in a rush. They called me and said, we have a client. It wasn't UKT, it was someone else. We have a client, and he's getting a student visa, and we only have 2 weeks. Can you get him a discharge without conviction tomorrow? As if, like, we can just go to court and say, can we have a discharge without conviction? And the judge says yes. And we said no. We can't do that so quickly. That it will take time. Anything going through the court will take time. So sometimes you have clients that they have 1 year or 2 years left of their visa. Perfect. That would work really well, because during that time period we can work with you and we can actually put in the application. We're talking about substantial application. Submissions, we need expert opinion, the same way that Mr. Lauren provided an affidavit and Mr. Saul provided an affidavit. The judge is not just going to rely on our opinion, because we're not experts when it comes to immigration law. So it is kind of your duty to give that assistance to the criminal lawyer that you're working with, to provide that framework for the judge as experts. So I would say usually the minimum to get someone a discharge without conviction would be 3 months. Because these days, because the courts are so they call it overworked, the kind of like the time frame between each appearance is at least 4 to 6 weeks. So if you have a client, I understand Katie had a client that he pretty much had 1 week in order to sort out his visa. The work visa was about to be apparently granted, or it was getting considered, and then he got himself charged with drink driving. And we told him that it would take at least 2 months for us to do a discharge without conviction. He didn't have that time because immigration said that we're not going to grant a work visa until the outcome is determined, either guilty or not guilty. So he had to leave the country if he wanted to apply for a discharge without conviction, then come back for a sentencing, and then we should have taken it from there. But he made a decision, despite knowing the consequences, that he wanted to put in a guilty plea because he didn't want to wait for a discharge without conviction. So that's a bit unfortunate on the part of the immigration, but they do want an outcome one way or another. And if there is not enough time for you to instruct a criminal lawyer to actually work with you for a discharge without conviction, you should put to them the consequences of not applying for a discharge without conviction. But then it is going to be up to them whether they want to plead guilty or whether they prefer to leave the country and go down the track with a discharge without conviction. So the time frame is quite important. As I said, a lot of people think that it's easy to get these applications through. It will take time in terms of doing the application and getting it to court. So one thing that I was going to mention is we have recommended this to a few other immigration advisors who approached us in the past 2-3 weeks. We think it's important for them to know about the deportation liability at the beginning when they come to you. So when they're getting on board, there's a letter of engagement. I don't know, this is how we operate. It's important for them to know about that potential because a lot of them are not aware of that. And they think, well, you know, I'm going to get residency or I'm on a work visa, a simple drink drive is not going to affect that. And then suddenly they get a shock that they're facing a deportation liability. So we usually suggest that you put that somewhere so they are aware from the beginning about that deportation liability. So at least if they're going to commit an offense, they would do it after the 2 years of residency. So that's not going to actually put you under that undue stress and pressure to get them deal with immigration and then they get a discharge without conviction. Because I had that comment from somebody, said, had I known that, I wouldn't have done this. So that would be the attitude they sometimes have. And you know, when they don't get their visa application approved, it's always your fault. And when they don't get a discharge without conviction, it's always our fault. So we are the ones who will get the blame at the end, somehow, one way or another. So to let them know at the beginning, at least you put them on notice, and they knew they can't blame you for not telling them actually that this would be a serious offending from the immigration point of view. So as I said, a few consultants that I know, they have added that to their initial letter of advice to their clients. And it would also be good to advise them that they should inform you immediately when they get charged with an offense. Again, that's something they don't do because they don't see the seriousness of that. And I know some advisors, they're not aware of the deportation liability, especially on a residence visa. And we had a recent case which immigration was not, they went through the appeal process, the deportation notice was upheld, and he was really about to be deported. So the only option that we had, instead of a judicial review, because judicial review is quite expensive for some people, the only option we were left with was to apply for seek a rehearing of the sentence. So we had to put a separate application to explain why we were seeking a rehearing. And of course, after the rehearing was granted, then we had to put in a discharge without conviction application, which pretty much cost them 4 times more than just getting a discharge without conviction application at the beginning. So that's something that is important for them to know, because sometimes they're embarrassed, sometimes they're scared, and they just don't think it's going to make any difference. It's important for them to know that they have to let you know. Because if they don't and they do something, it's going to affect you and it's going to affect their visa application. And the other thing that I would like you to know, because we've been working with Kim for the past, I think, 9 or 8 years, but I tried to work with another immigration advisor because the client wanted him to do the affidavit, and he outright refused to do it. He said, I'm not going to tell the court that he might be deported, because that's not the truth. And I said, well, how can not be the truth? The section is right in front of you. And he was super worried that he might be facing consequences. And we were just asking him to put his expert opinion in a form of an affidavit. He refused to do that, and we got him to do it at the end. So that there is absolutely no harm for you guys to do that, because the court, as I said, will not rely on our opinion. We're criminal lawyers, we're not immigration lawyers. So we would never ever do an application without having a supporting affidavit from an advisor or an immigration lawyer accompanying the submission explaining the law. So there's absolutely no harm in doing that, and I think you must do that in order to help your client, because otherwise they will probably have to go to someone else to get that done. So pretty much, that's pretty much it. I think I try to summarize it as much as I can. And again, it is highly important for you to advise them at the beginning about the deportation liability. I've seen it on so many occasions that deportation notices, the deportation liability notices do get issued. One thing, I didn't mention it here, but immigration sometimes wait for a very long time before they issue the notice. I recently had a call, he was a referral from another client, and he said that he pleaded guilty to a driving while disqualified, which carries the same sentence, up to 3 months imprisonment. 3 years ago, Patrick, I think, 2 years ago. And he got convicted, he served his disqualification, and it was all finished. So they went to apply for the permanent residency 2 years after, and then the immigration wrote back to him saying, you're liable for deportation, so we're going to serve you with a deportation notice. And he simply couldn't believe it. He said, how can they do that? So the gist of the story is that they can do that 2 or 3 years after. They might not notice it, they might not be made aware by the court, but at the time that your client is going to apply for citizenship or permanent residency, sorry, not citizenship, for permanent residency, they suddenly might realize that they're facing a deportation. So they're going through the process at the moment with Kim and Patrick. So that's another thing for you to know. So for them, again, summarizing it, to know that there is a way out of it in terms of getting a discharge without conviction. That means they don't have to declare the conviction to immigration. Even if they do declare the conviction to immigration, we have received confirmation from immigration officers here in New Zealand, a few from Canada, that they do understand the concept of discharge without conviction. So the email we have received said, if your client get a discharge without conviction, that would be acquittal, and we will consider it as no conviction. So they do recognize it, okay? Sometimes you do come across immigration officers who don't know what they're doing. So again, it's your job to bring it to their attention. And it would also be a good idea, I don't know why, but as soon as you involve someone in a criminal law, with a criminal law experience or expertise, to do a letter to immigration, they kind of back off. I've seen it before, that they did issue a deportation notice for someone who got a discharge without conviction. It was a year ago on a residence visa. And we did a letter, attached the decision, and they just came back apologizing for issuing that notice, and they withdrew the notice immediately. And the cost threat is always a good threat as well. So that would be the interface between having a discharge, applying for a discharge without conviction, and a deportation liability. So all you need to know is that your clients are not safe within the first 2 years of their residency, and there is a way out of it if you actually need to protect them from deportation liability. So I'm happy to answer any questions if I have any time.